Afternoon, and thank you for joining us today for Lecture 3 of the JGLS Insolvency Law Public Lecture Series. I'm very excited for the speaker today, who's Dr. Wee, who is an associate professor and a co-director of the Asian Law Institute, and also the deputy director and head of corporate law of the E.W. Baker Center for Law and Business at the Faculty of Law, National University of Singapore. Now, I know that we live in a Google generation, and you have extensively looked up our speaker today anyway, but a little bit about his accolades before I let him have the floor is that Dr. Wee was an editorial member of the Singapore Journal of Legal Studies. He obtained his LLB from NUS. He was BCL first class and also did his doctorate from Oxford. He teaches corporate insolvency law and company law at the National University of Singapore and has published countlessly in several journals. His writings have been cited by the Supreme Court of Appeal and the Australian Federal Court. And he was a member of the Insolvency Law Review Committee and was a visiting professor as well in various law schools, including our own at Jindal Global Law School for this guest lecture series. Now, a little bit about the format of this session. We're going to first hear from Meng Seng, who will be taking us through the Singaporean restructuring regime and give us insight into what the law was and what the law is, and followed by a brief Q&A on how that is used in the current scenario to contextualize it to India. Now, without further ado, I want to invite Meng Seng to the floor to take us through this insightful presentation on the Singapore corporate insolvency and restructuring regime. Welcome, Meng Seng.
Yeah, thank you, Ishana. Yeah, good afternoon, everyone. I'm honored and to be invited by Jindal Global University to present this lecture. Okay, and thank you for taking time off to participate. Now, so my talk today is about Singapore's corporate insolvency law, the old and the new. Right now, so to begin, just a very quick snapshot of Singapore's legal system. As you all would probably know, Singapore is a former English colony dating from 1819. Singapore gained independence in 1965. Now, the colonial era laws were not repealed when Singapore first became a state, when Singapore left the British Empire and became a state in Malaysia. The laws were not repealed, and also the laws were also maintained when Singapore left Malaysia to become an independent country. Moreover, there was even continued reception of English commercial law until 1993. Now, so that is the backdrop. Now, insofar as corporate insolvency law is concerned, insolvent winding up and receivership were the only formal insolvency proceedings for a very long time. Now, but that changed in 1986 when Singapore suffered a major recession and the government adopted the English administration with some changes. Now, we call this new procedure judicial management. Now, we fast forward to 2010. The government appointed the Insolvency Law Review Committee, right, of which I was a member, to conduct a thorough review of both personal bankruptcy and corporate insolvency laws. Now, I think actually I should stop here to mention briefly that I have prepared quite a number of slides, and I apologize, the slides are rather wordy. Now, I think because I hope that that will give you more information that you can refer to later when you have free time. You can read them. But when I bring you through the slides, I won't be just reading from them. So these are more like just a platform for me to conduct today's talk. Okay, so moving back to the ILRC. Now, this reported in 2013, it recommended very substantial reforms. And for our purpose, the important thing is that it introduced injecting modified elements of the US Chapter 11 into schemes to create what I will call the hybrid scheme, now which is a more powerful rescue procedure. Now, the IRRC also recommended adopting the ancestral model law on cross-border insolvency. So that was 2013. Now, shortly after that, in 2015, the government appointed another committee, the committee to strengthen Singapore as an international center for debt restructuring. Now, I think the mission of that committee is obvious. I don't have to explain further. Now, this committee recommended further reforms to the entire legal system to enhance Singapore as an international hub for restructuring. Now, so pursuant to the work of those two committees, there were two phases of legislation to implement the reforms. First, there was the Companies Amendment Act 2017, which created a hybrid scheme and adopted the model law. Adopted the model law and also updated some elements of cross-border insolvency law. So that was the first phase. Now, in the second phase, the Insolvency, Restructuring and Dissolution Act 2018, I would call that ERDA. This brought together personal bankruptcy and corporate insolvency in one statute, for the first time. So we now have an omnibus. Legislation. Now, this act was passed in 2018, but it became law only last year in 2020. Now, Chief Justice Menon has referred to ERDA as a game changer. So I shall explain to you why the Chief Justice is of that opinion. But before we get into the exciting bits, I should very quickly bring you through winding up. Now, winding up is, of course, not glamorous or exciting, but it is actually important to have a proper appreciation of what winding up is all about. Now, very quickly, now we have two kinds of initiation of winding up. It can be voluntary winding up, where members pass a winding up resolution, or compulsory, where the court makes a winding up order. Now, it is important to note that how winding up begins has no relation to whether the winding up is solvent or not. Now, so for a voluntary winding up, it can either be solvent or insolvent. Now, it will be solvent if the directors make a declaration of solvency. Now, but if directors do not make that declaration, then the company is presumed to be insolvent and you'll be treated accordingly. Now, as for compulsory winding up, again, the company may be solvent or insolvent, right? Depending on the ground for winding up. Now, so why do I say that winding up is important? Now, first, I think it is important to appreciate that whereas rescue, of course, things like rescue, restructuring, they are important, but some insolvent companies are simply not worth rescuing and should be wound up. Now, here it is essential to distinguish between business and economic failure on the one hand from financial difficulty on the other. Now, in the former, where the company's business model does not work, you can't rescue the company, right? Because the company cannot survive in the business environment. Now, on the other hand, if the reason why the company is in difficulty is because of some financial reasons, but the business model is sound, in this case, it will make sense to lighten the company's debt load, reduce its liabilities, put the company on the better financial footing so that the company can then go back to its business and continue to contribute to society and preserve jobs. So it's important to appreciate that. Now, secondly, insolvent winding up provides a baseline for all the parties concerned, for the company, for the creditors, and for the court to assess whether or not to accept or reject the proposed rescue. Now, because rescue involves risk, right, and it's not cost-free, so if the rescue is unsuccessful, the company may end up being from bad to worse, right, and everyone will suffer. So therefore, at the very least, creditors will want to be assured that they will be getting something better from the proposed rescue than compared to what they would get if the company were being wound up. Now, thirdly, the reason why insolvent winding up is so important is because this is the final forum for us to hold directors and management accountable for breaches of duty, right? Because we know that when a company is a going concern, it is very difficult to sue the directors, right, for breaches of duty. So winding up provides the final forum. And in fact, for jurisdictions like Singapore and UK, it also provides the platform and the forum, okay, to disqualify directors who are unfit. Now, finally, there's a winding up provides the ultimate disciplinary role of credit. Now, an unpaid creditor's petition to wind up a company or a threat to present a petition is a form of market discipline, right, for companies. Now, this will force directors to embark on a rescue, okay, to think about a rescue or to wind up the company or to take whatever action that's appropriate in the circumstances. Now, under the threat of a petition, or actually when the petition is presented, the directors cannot just refuse to do anything and just hope, sit there and hope for some miracle from the sky, right? So therefore, this provides a disciplinary function and prevents insolvent companies from incurring more credit, okay, which they could not repay ultimately. Now, okay, so that's all I want to say about insolvent winding up. Okay, let me now bring you through global receivership, right? Which, as I said earlier, is one of the two insolvent corporate insolvency procedures for a long time. Now, okay, so this is a simple diagram. In the security document between the company and the debenture holder, okay, the debenture holder will delegate the power of appointing a receiver when the company has committed an event of default, okay, to the company. Okay, so this power that is given to the company cannot be revoked. On the occurrence of an event of default, okay, the debenture holder, okay, can appoint a receiver and manager out of court, right? Because this is a contractual arrangement. Now, this receiver and manager, okay, enjoys wide powers, okay, to preserve, to manage, and to sell, okay, the company's assets. Okay, so the receiver can run the business and sell the assets. Now, for what purpose? Okay, obviously the purpose is to procure the discharge of the debts owed to the debenture holder that appoints the receiver. Now, so the receiver owes primary duties to the appointer, okay, to the appointing debenture holder. Now, so that is the function of the receiver and manager appointed by the debenture holder. Now, please note that to shield the debenture holder from liability for the acts of the receiver and manager, okay, the document will also provide for the receiver and manager to be the company's agent. Okay, to be the company's agent, not the debenture holder's agent, the company's agent, to manage and realize the security for the benefit of the debenture holder. Now, so that is the basic the principles of a global receivership. Now, here I want to emphasize that this is the reason why I use the word global in front of receivership is because there are many different kinds of receivership. Now, the receivership here I'm talking about extends to all the assets of the company. Okay, as I'll explain here in this slide. Now, so this is a very speedy, flexible, and powerful debt enforcement mechanism for a secured creditor with a global security package. Okay, so this secured creditor, I refer to it as a global security holder. Now, so what does this security package consist of? Now, it consists of one or more fixed charges over fixed assets of the company. For example, the land, the building, things like that, fixed assets. Now, and very importantly, okay, there will be a floating charge over the rest of the assets. So when you look at the combination of the fixed and floating charges together, they cover the entirety of the company's assets. Right, so that's why I use the word global. Okay, now this is to be distinguished from a receivership over only a particular piece of asset. Okay, so that is not something we're interested in today. Now, so the global receivership became possible because of the invention of the floating charge in late 19th century England. Right, so the floating charge can cover, right, all the other assets of the company. Okay, I mean the non-fixed assets. Now, in the appointing of the receiver, and indeed in the entire conduct of the receivership, right, no application to court is required and court involvement is minimal. Now, this is clearly not a collective procedure, right? It is a debt enforcement mechanism for the benefit of the global security holder. Now, so in this sense, this is very different from a winding up, okay, and most other insolvency procedures. Now, it is not a terminal process, okay, not a terminal process, okay, unlike winding up. But the thing is, in practice, after the end of a receivership, the company will usually end up in winding up because the company will be left with little or no assets. Now, although this is designed to enable the discharge of debts owed to the appointing creditor, okay, the global security holder, now in principle, okay, the global receivership is capable of enabling the preservation of the business of the company on a going concern basis. Now, why do I say that? The reason is because since the security is over the entirety of the company's assets, right, a sale of the business, okay, of the company's business, the company's assets on a going concern basis is possible, right? Now, as I told you earlier, okay, the security document will give the global receiver wide management powers. So these wide management powers will enable the receiver to trade, okay, to continue to run the business, okay, so that it can put the business into a better shape, okay, pending a sale of the business on a going concern. Now, I think we can all see that if this can be done, right, sale of the business as a whole, rather than selling off the assets piecemeal, this will realize more for the benefit of not only of the appointing creditor, but also for all the other creditors. Okay, but the trouble is that in practice, there's little incentive for the global receiver to do that, right? To continue to run the business, okay, and then to try to find someone to buy all the entire business of the company. Okay, there's no incentive to do that if the appointing creditor is fully secure. And all that the receiver needs to do is just sell off some assets here and there, right? Piecemeal. And that is enough to pay off whatever debt the company owes to the appointing creditor. Now, so if that's the case, then there is no reason. And in fact, the global receiver will come under some kind of duties, right, when he runs the business. Now, so in UK, as you can see that, concerns about the accountability, as you can see that there will be concerns, right, about the accountability of such a mechanism, right, and whether it is fair and just. Now, in the UK, concerns about such things led to the virtual abolition of the administrative receivership. Okay, I will not get into what this means. Okay, it is enough just to understand the administrative receivership as a kind of enhanced global receivership. Okay, so this administrative receivership was virtually abolished in the UK in favor of administration, now which is of course a collective procedure. Now, by contrast, or you may say in contrast, the global receiver is still available in Singapore. It is still part of Singapore law. Now, there are only a few sections of receivership in EDA. Okay, so receivership is still available in Singapore. Now, but this is not to say that the Singapore courts may not develop the receivership further. Like for example, to try to introduce, to try to improve the law so that the global receiver comes under more accountability, right, to the company. Now, but let me now move on to judicial management. Now, as I told you, judicial management was introduced into Singapore in 1986. Now, this is largely similar to the UK's administration before the UK reformed her law of administration in the Enterprise Act of 2002. Now, in Singapore, there are two routes into judicial management. Okay, two ways. First is the court-ordered JM. Now, in this case, either the company or creditor may apply to court for a JM order. Now, if the conditions are satisfied, okay, like two conditions. First, the company must be either insolvent or going to become insolvent. And secondly, the making of an order would achieve certain purposes, which I will mention in a minute. Okay, so if those conditions are satisfied, the court appoints a judicial manager with extensive powers to manage the company. The directors will lose their powers of management. Now, but please note, this is quite important. If a global security holder objects to the JM application, okay, if there's such an objection, the court will have to carry out a balancing exercise, right, to decide whether to override the objection from the global receiver. Now, so that's the court-ordered JM. Now, as for out-of-court JM, now this is a new option, very recent, okay, introduced pursuant to the EDA. Now, in this case, the company may put itself into JM okay, where the global security holder does not object. Now, so this is a simple diagram of a the procedure involved in a court ordered JM. First, there's an application as I told you. Okay. Now on the application, an automatic moratorium will come into effect. Okay. This is called the automatic moratorium period. And during this period, the court may also appoint an interim judicial manager. Now, so on the hearing, the court will choose a date to hear the application. If the application is successful, the court will make a JM order. Now, so what are the effects of the JM order? Okay, first, the initial automatic moratorium becomes a general moratorium. Okay, so this general moratorium prevents creditors from enforcing their claims against the company, right? Not only unsecured creditors, but also secured creditors. So this gives the company a breathing space for the company to decide the next step. Now, so under the protection of the moratorium, the company will cease payments for pre-existing debts, for the old debts, okay, but the company will have to pay for the new supplies, okay, during the period of the JM. Now, the judicial manager will displace the directors, right? Directors lose their powers, and if before the JM a receiver has been appointed, the receiver will also have to vacate office. Now, so the judicial manager, right, will run the company's business and come out with a statement of proposal on how to bring the company forward on the exit option from the JM. Now, he will hold a meeting, okay, of the creditors, the Section 108 meeting, okay, for the creditors to vote on his proposals. He will then implement the proposals accordingly. And as you can see, there are a few exit options. Okay, the worst is, sorry, not the worst. There are a few exit options. First, can be either survival of the company or sale of the business or a Section 210 scheme. Now, I'll talk about these exit options a little bit more later. Please note that pursuant to the reforms in ERDA, okay, a judicial manager now may also apply for rescue financing. Okay, so this is the procedure for a court-ordered JM. Now, as for out-of-court JM, you can see there are a lot of things on the slides. I do not intend to go through everything. Okay, it is not necessary. Now, first, the directors must lodge a statutory declaration, okay, with the registry of companies on certain things, like for example, company is insolvent, okay, and that the directors believe that the objectives of the JM will be, one of the objectives of JM will be achieved. Okay, okay, so that is the statutory declaration. Now, the company must also give notice, right, to, very importantly, to the person proposed to be the interim judicial manager, okay, and also the global security holder, right? You have to give notice to the global security holder in order for the global security holder to decide whether to support the company putting itself into JM or not. Now, so after doing those things, there are further conditions to be satisfied. Okay, the company must pass a members' resolution. Okay, and the proposed interim judicial manager must agree to act as interim judicial manager. Now, so once those things are satisfied, the company will go into what you may call an interim judicial management. Now, during this period, the interim judicial manager, okay, has all the functions and powers of an ordinary judicial manager, okay, unless it is restricted by subsidiary legislation, which so far there's been nothing. Now, the appointment of this interim judicial manager will also trigger an automatic moratorium period. Now, after that, the company will then hold a creditors meeting, right? The creditors have to be involved, okay, for them to vote on whether they agree that the company should put itself into JM. Okay, so that is the out-of-court JM, the alternative route introduced by ERDA. Now, as I mentioned just now, okay, there are a few objectives for the JM. Okay, the first and you may say the best is survival of the company, right? So the company survives. Now, but usually that is very hard, right? What is more likely is that the company may not survive, but the whole or the part of the undertaking, meaning the company's business as a going concern, okay, may continue, may survive. Okay, so that is one possible objective, or you may say two possible objectives. Okay, next is the approval of a scheme of arrangement. Now, that is something I'll talk about in great detail later. Okay, to approve a scheme of arrangement. Now, the basic idea here is to restructure the company's debts. Okay, and lastly, okay, if those things cannot be achieved, okay, the judicial manager may hope to achieve a more advantageous realization of the company's assets compared to an insolvent winding up. Okay, so those are the objectives of JM. Now, I told you already there will be a moratorium, and moratorium is indeed the most important feature of the JM. Now, the judicial manager, you may wonder who is this person, right? He or she needs to be a qualified insolvency practitioner, okay, to be appointed by the court. Now, so I think you can see that the judicial management is more facilitative of a rescue outcome for a financially distressed company than insolvent liquidation, right? Because there's there are inbuilt mechanisms to facilitate a better outcome. Now, so I mentioned that it can be rescue of the company itself, but usually this is very hard, right? It will typically require a restructuring of the company's existing liabilities to reduce the company's debt burden. Now, this may be difficult to negotiate, right? Because you will need to get the consent of all the creditors. Now, so if it is not possible to negotiate, you may have to use a scheme of arrangement, right? Because through a scheme of arrangement, you can bind dissenting creditors. Now, but if this is the case, it will mean that you need to twin a JM with a scheme. That means you need to have two procedures at the same time. Now, and there's little reason to do that in Singapore, right? I mean, if you are thinking of trying to rescue the company through doing a scheme, you don't have to put the company into JM first, right? You just do a scheme directly. Okay, so that would be rescuing the company itself. Now, how about but then if that is either you want to do it through scheme, right, or if that is not possible, right, it can be rescue of the business, right, either in whole or in part. Now, in this scenario, after you sold off the business, the company will then enter into insolvent liquidation. Now, finally, it can also be a more advantageous realization of the assets compared to insolvent liquidation. Now, in this case, this may either be piecemeal sale of the assets or a sale of particular units of the company's business. Now, in fact, the last one, more advantageous realization of assets compared to insolvent liquidation, this is the most common outcome in JM. Now, this is, of course, rather depressing, right? I mean, that suggests that JM has not been that effective in rescue. In fact, JM has been largely moribund in recent years. It is very unpopular. Okay, unlike the scheme which became popular around 20 years ago. Now, what are the reasons? Okay, first, of course, in the JM, the directors lose their powers of management, right? But in a scheme, there is no such mandatory requirement. The directors can continue in office and continue to exercise powers, right? The scheme is like Chapter 11, a debtor in possession regime, right? So that's one important reason. Now, next, a company is usually beyond rescue by the time it enters into JM, right? So not possible to rescue. Finally, the scheme has a bad reputation, right? So unfortunately, JM, and indeed I will add, right? Indeed, I will add the UK administration in the UK has also not been popular in the UK. Now, before 2017, before the reforms in 2017, global receivership has precedence over JM. A global security holder has a virtual veto against a company entering into JM. Now, so of course, this is quite good for a global security holder. Now, but if you look at the structure of insolvency law, it may be seen to be too pro-secured creditor, and therefore not so fair, right? Not so just. Now, so the JM was reformed in 2017. Now the court may make a JM order over the opposition of a global security holder. Okay, the court will carry out a balancing exercise. Okay, and there are also special provisions now for rescue financing in the JM, similar to that in the scheme. So these reforms have made the JM, the relationship between the JM and the global receivership now more balanced. Now, before we leave JM, I should mention briefly some recent developments. In England, the prepackaged administration became very popular after 2002. Now, I told you earlier that in the UK, administrative receivership was virtually abolished in 2002. Now, so as part of the market reaction to this abolition, a practice grew up, okay, of prepackaged administration, right, where the most of the work, or in fact all the work, was done before the company put itself into administration, and the administrator, after he or she is appointed, will immediately execute the sale agreed beforehand, before the administration. Now, so you can see that this kind of procedure where the creditors are not involved, okay, the only creditors that are involved are the powerful creditors, okay, and of course the company's management and directors are involved. So there is a lack of accountability to the general creditors, okay, in the prepackaged administration. This was very controversial, and the UK government has recently, okay, very recently introduced new rules to curb abuse. Now, in my opinion, I think a prepackaged JM in Singapore is unlikely. Okay, the reason is simple, because the global security holder can just simply appoint the global receiver, right? So unless the court objects lah. Okay, so Singapore in this case, in this sense, offers more flexibility compared to the UK. Now, there's scope, okay, for the market to leverage on the system, the inherent flexibility of the system in Singapore, to find effective and efficient solutions, to find the most effective and efficient solutions to choose between JM, global receivership, and I will explain in some detail later the scheme of arrangement. And the judiciary, right? The Singapore judiciary is highly supportive of and innovative, okay, with regards to new developments. Okay, now before we leave JM, okay, I should mention that the JM jurisdiction in Singapore extends beyond Singapore incorporated companies. So foreign companies may also apply for a JM order, provided it has substantial connection to Singapore, okay, some kind of links to Singapore. Now, so for example, the COMI, okay, or the company's property or businesses in Singapore, or there's a Singapore jurisdiction or choice of law clause in either loans or other transactions, okay, etc. So those things will constitute substantial connection to Singapore. Now, what this means is that, therefore, regional companies may access GM in Singapore. I mean, if they think that this is good for their restructuring. Okay, so I will now discuss the scheme of arrangement. Okay, now this is a very versatile statutory procedure. Okay, it is in section 210 of the Companies Act. It enables a company to enter into a scheme of arrangement with its creditors and or members. Now, it is not an insolvency proceeding, okay, unlike JM or receivership or, of course, winding up. Now, in essence, okay, a scheme of arrangement is simply a corporate procedure to enable a majority to buy a minority, okay, to achieve a broad range of corporate objectives. Okay, so for example, takeovers, okay, reorganization of the share capital, okay, to achieve a moratorium with creditors, or to restructure the company's debts, okay, for example, to extend and amend, okay, to achieve haircut or debt equity swap. Okay, so you can see that the users of the scheme of arrangement, okay, as a corporate procedure is potentially limitless. Okay, so long as it is lawful, okay, there should be no problem. Now, so over the last 20 years, the scheme became a very popular vehicle for rescue in Singapore, in London, and Hong Kong as well. Okay, there have been many examples of successful schemes in Singapore. Now, it is usual to say that a scheme involves 3 stages, but I think that is a little bit simplistic. It is more accurate to say that a scheme involves 5 stages. Okay, now at the stage 1, okay, there's impetus. Okay, the company is in some kind of financial difficulty. Okay, the company will try to formulate a proposal with the help of an insolvency practitioner. Okay, the company enters into negotiations with creditors, okay, on how to restructure its liabilities. Okay, so when there has been some kind of agreement, broad agreement on how to rescue the company, okay, and some documents are ready, okay, the company will apply to court, okay, for the court to order meetings to be held. Okay, so this is usually referred to as the convening hearing. Okay, convening hearing. Now, if the convening hearing is successful, the court will order creditors meetings to be held. Now, so that's the second stage. Now, at the third stage, okay, the company will send explanatory statement, okay, because the company needs to inform the creditors of what is involved, right? And to put the creditors in a position for them to decide what is in their best interest, okay, whether to support or to reject the proposal put up by the company. Yeah, so the explanatory statements, okay, with all the requisite information will be sent to the creditors, okay, and the notice of meetings as well. Now, at the fourth stage, okay, the creditors meeting will be held, okay, where the creditors will vote on the proposed arrangement. Now, so if the requisite majority is obtained, okay, the company will go back to the court, okay, a second time. Okay, now of course, when I say a second time, in between, if the company requires the court's directions on issues, the company can, of course, always approach the court. Now, but in the absence of that, okay, this is the second time the company will go back to the court. Okay, the company will apply to the court for the court to sanction the proposal that has already been approved by the creditors. Now, so if that is successful, okay, the court will grant an order to sanction the arrangement. Now, you notice on the right-hand side of the slide that the company, okay, may apply for a stay under Section 21010. Okay, that means to stay creditors' actions against the company, right? That is under, this is something that we always have, okay, as part of our law on scheme of arrangement. Now, but recently, because of ERDA, as I told you earlier, we brought in US elements, okay, and make and create something called the hybrid scheme. Now, so one important element of the hybrid scheme is the moratorium under Section 64, which I'll mention in some detail later. Now, I have talked about creditors meetings. Now, is it necessary to hold members meetings? It depends, right? It depends on whether you are going to extinguish the company's extinguish the members' shares. Now, if you propose to do that, okay, members meeting would be required. Now, upon the court's sanction of the arrangement, okay, it becomes binding on all classes of creditors on the company, and if members are involved, the members as well. Okay, so even creditors who fail to appear at the meeting or who object to the proposal, they will all be bound, okay, by the court order. Now, so the ultimate, I think it is important to have an appreciation of the linkages, right? The common heritage between the former, the Commonwealth countries. Now, ultimate predecessor of Section 210, okay, was an English Act of 1862. Now, this English version has been copied and adapted in many Commonwealth jurisdictions or former English colonies. Right, so for example, Singapore, Malaysia, Australia, and of course India as well, and the Hong Kong Special Administrative Region. Now, so therefore, I think it is correct to refer to the Section 210 scheme, okay, as a Commonwealth scheme. Now, of course, between the different jurisdictions, there will be some differences, minor differences, or some maybe even a bit more major. But you can see that there's a common heritage. Now, the company's amendment at 2017, okay, brought in elements of the US Chapter 11, okay, with regards to creditors schemes, okay, to come out with a more powerful rescue procedure. Okay, I call that the hybrid scheme. Now, so what are the elements brought in? Okay, there are 4 elements. Okay, first is the enhanced moratorium, okay, which is similar to the moratorium in the JM. Okay, secondly, there's a cross-class crampdown. Okay, and then the super priority rescue financing, and finally the pre-packaged scheme of arrangement. So I will go through each of them one by one. Now, but before we get into that, I should say that as with JM, regional companies may also access the scheme and the hybrid scheme, okay, provided it has substantial connection to Singapore. Okay, so that is the the connection to Singapore that is needed, okay, in order for the Singapore court to exercise its discretion to assume jurisdiction to hear a scheme that is proposed by a foreign company. Okay, now as you can see, this is important. This extension of jurisdiction to regional companies is important because this enables Singapore to provide its services to companies in the region and perhaps even beyond. Okay, if they think that the restructuring laws in their own jurisdictions, in their home jurisdictions, are maybe somehow not so appropriate for restructuring, okay, and they think that Singapore, both because it is a international financial center, okay, and also because we have these new procedures, okay, they may therefore choose to come to Singapore to restructure. It is similar to how companies around the world have gone to either New York or London to conduct restructuring. Okay, so there is a enhanced moratorium. Okay, the company may apply to the court for a moratorium. Okay, now at the same time, when may the company apply for that? Okay, this will be at the same time when it files for the scheme of arrangement. Okay, when it applies to court, okay, for the court orders to convene meetings, okay, at the first hearing, okay, or even earlier, okay, when it intends to propose a scheme. Okay, as essentially what this means is when restructuring is contemplated. Okay, because sometimes you need protection earlier before you are ready to apply to court for the first hearing. Now, there is no express insolvency requirement here. Okay, just to note that the filing documents must include evidence of creditor support, okay, and an explanation of how such support would be important for the success of the proposed scheme. Now, I think this is important in order to protect the interest of the creditors of the company, because we do not want to allow a company, okay, where the management is suspect to use the excuse of wanting to do a scheme of arrangement, okay, to apply to court and therefore obtain a moratorium immediately in order to frustrate creditors. Now, the effect of the application is that immediately on filing the documents at the court, there's an automatic 30-day moratorium. Okay, this applies to both secured and unsecured creditors. Now, and if the application is successful, okay, the court will hear the application within 30 days or less. Okay, if the application is successful, the court will grant a moratorium. Now, the initial period of the moratorium is at the court's discretion. Usually, it will be a few months, okay, depending on the facts of the case. Now, and let's say if the restructuring is very complex and the company needs more time, okay, the company may go back to the court to apply for an extension of the moratorium. And the court may extend at its discretion. Okay, there is no time limit imposed in the statute. Now, but in practice, the court will require evidence of progress, okay, that there has been good progress before it will grant an extension of the moratorium. Now, unlike the practice, or I mean the law in many countries, the moratorium here may extend. Okay, the moratorium here applies not only to the particular company applying for it, it may also be extended to a subsidiary, a holding, or ultimate holding company, okay, of the applicant company. Now, this is thought to be necessary because in today's day and age, right, businesses in a group are tightly linked. So sometimes, although it is the company that's applying for a moratorium, you may need protection. Okay, the other companies in the group may need protection. Okay, so we have this facility in EDA. Now, next, there is now scope for you may say extraterritorial reach of the moratorium. Okay, an order may be expressed to apply to any act of any person in Singapore, okay, or within the jurisdiction of the court, okay, whether the act takes place in Singapore or elsewhere. Okay, so the requirement is that the person concerned, okay, in other words, the creditor, okay, must be either in Singapore or within Singapore's jurisdiction. Okay, now if that is the case, the moratorium can apply to such a person even if the act of the person may take place outside of Singapore. Now, as I mentioned earlier, it is important to protect creditors' interests, okay, in such a situation, okay, because this is a debtor in possession regime. the company is protected from actions from the enforcement actions from the creditors. So you want to ensure that the company's management does not abuse this moratorium. Now, so certain arrangements are excluded. For example, set off or netting arrangements, okay, and security interest arrangement, they are excluded. Okay, and also the moratorium is subject to court supervision and control. If a creditor thinks that its interest is being unfairly treated by the company during the moratorium, it can apply to court for the court to lift the moratorium. So that is the moratorium. Now we will now look briefly at the crampdown of dissenting classes. Right. A company will clearly have creditors with different rights against the company, right? Secured creditors, preferential creditors, unsecured creditors, and the restructuring may also treat creditors differently, right? Because you want to find the most efficient solution. Now, so to ensure that creditors are treated fairly, creditors with different rights have to be put into different classes. You can't force, for example, a secured creditor, okay, to vote together with an unsecured creditor, right? I mean, that wouldn't be right. So within each, so therefore, okay, we may have to put creditors into different classes. Okay, now, so there are a few things to think about here. Now, if you are thinking about within a class, right, within each class, okay, we allow the majority to bind the minority. Okay, the majority for scheme is a majority in number representing 3/4 in value of the creditors present and voting on the scheme. Okay, but pursuant to a recent amendment, okay, the court may disapply the number majority. Okay, so only the value majority is still a prerequisite. Now, so this is what we may call cram down within a class, intra-class cram down. And this is what you have in Commonwealth schemes. Okay, there is no cross-class cram down. Okay, generally speaking, there is no cross-class cram down in Commonwealth schemes. Now, US Chapter 11 has cross-class cram down. Now, so this is a powerful device to enable a good restructuring plan to overcome hold out by one or more dissenting classes of creditors, right? Because they may be asking for more than what actually they should be entitled to. Now, under the Commonwealth scheme, right? Once you have a dissenting class of creditors, the court cannot approve the scheme because each and every class must approve. So the thinking from US Chapter 11 is that cross-class cram down is possible because sometimes objection from a dissenting class of creditors should be rejected. Now, but then the problem is, how do we know whether objection from the dissenting class is appropriate or not? Right? We need to put in protection to prevent dissenting classes of creditors from being treated unfairly. Now, so this is where the famous absolute priority rule comes in, okay, where we protect dissenting classes, okay, from being treated unfairly, but at the same time, if they are treated fairly and yet they still dissent, the court can cram down. Okay, so this is in a nutshell, okay, the requirements for cram down. Okay, court may do so if at least one class has consented. Okay, you need one class at least. And there's majority in number, okay, representing 3/4 in value of the totality of all the creditors. Okay, there is also no discrimination between the classes. Now I'll call this horizontal fairness. Okay, between creditors at the same level of priority. Okay, there is no discrimination. Now finally, there is fair and equitable treatment for the dissenting classes. So this is vertical fairness, right? That means we want to ensure that senior creditors do not work together with the company's shareholders and management to ill-treat junior creditors. Now, so in Singapore, okay, with regards to the fair and equitable standard, we adapted the American absolute priority rule. Okay, we draw on their ideas, okay, but we adapted them. Now, what is the absolute priority rule? In a nutshell, the idea is that, okay, if you have a particular class of creditors that has not been paid in full, then any class that is junior to this class, okay, be it another creditor class or a shareholder, okay, they are not supposed to get anything, okay, from the company. Okay, they are not supposed to retain their shares in the company, okay, unless the senior class agrees. Okay, unless the dissenting, unless the senior class that has not received full payment, okay, agrees to the junior class getting something. Okay, otherwise, if there is no such agreement, and the senior class has not been paid in full, then the junior class cannot continue to hold on to their shares, or their claims against the company will be extinguished. Now, so you can see that this rule prevents junior classes. This rule prevents the different claims against the company from jumping the queue. Right, so that's the absolute priority rule. Now, but unlike the American absolute priority rule that applies to all claims against the company and including the shareholders as well, interest in the company, okay, in Singapore, the absolute priority rule does not apply to equity interest. Okay, so that's absolute priority rule. Now, let me now bring you through rescue financing. Now, rescue financing may be crucial to sustain a company while it seeks to restructure, right? Because that will be it'll take a period of time. So during this period of time, you may need support financially. Now, so a company may raise rescue financing in both a scheme or a JM. Now, this is defined, the rescue financing is defined to mean financing that is necessary for the survival of the company or the whole or any part of the undertaking of the company as a going concern, right? Or to achieve a more advantageous realization of the assets of the company that are on the winding out of that company. Now, so you can see that the purposes here actually reflect the purposes, the objectives of a JM. Now, so that's the definition of rescue financing, right? It is broader than just rescuing the company, or I mean, it is broader than just the survival of the company. Now, insofar as the conditions that must be satisfied before you can have rescue financing, okay, we have adapted concepts from the US law on rescue financing. Now, the key thing to note is that there are different levels of priority to suit different needs. Now, and the court approval process ensures protection of the interests of the conflicting interests of the parties, right? The company and the creditors. Now, so these are the different levels of priority, right? I mean, I will not go through them. I mean, unfortunately, I don't have much time today to do this. So I said there are different levels. Now, the last thing, the thing perhaps I want to point out is the priming lien, right? So this enables the court to grant to the rescue financier a security that is ahead of all the company's existing security. Right, so this is a very powerful device, okay, but there are stringent conditions imposed to ensure that the creditor whose security interest is being trumped, okay, is treated fairly. Okay, so as you can see from the slide, there must be adequate protection for the interest of the existing security holder. Okay, there is okay, so that is rescue financing. Now, prepackaged scheme. Okay, now this is adapted from the pre-pack chapter 11, right? The idea is basically that if it can be seen that had a creditors meeting been held, the requisite majority will be obtained. So why do you want to waste time and effort and money, right, to hold a creditors meeting, right? So that is the idea here. So if you can present evidence to the court that without holding the creditors meeting, there's enough evidence, satisfactory evidence that had the meeting been held, the requisite majorities will be obtained, then that's all right. The court can still sanction the scheme, right? But of course, you know, with this, what it means is that a cram down of a dissenting class is not available. Okay, so I will now conclude. Okay, I don't have time to talk about the exciting developments in Singapore's cross-border insolvency landscape, so I'll just provide a nutshell here. Now, Singapore has adapted the model law, the ancestral model law. Now, our version is very similar to that in the UK and the US. Okay, all three countries follow the model law very closely, and there is no reciprocity requirement. Okay, so we do not require, if there's a request, for example, from India for assistance. Now, although India has not adopted model law, to us that is not a problem. Okay, now further, Singapore judges have been extremely proactive in promoting communication and cooperation, okay, across borders. They pioneered the Judicial Insolvency Network, okay, which is a network of leading insolvency judges from around the world to encourage communication and cooperation, and also to provide thought leadership. Now, and the GIN has bore fruits. It has already developed the GIN guidelines for court-to-court communication and cooperation and the modalities of court-to-court communications. Now, although these things are in theory, not something that's so exciting, but in practice, they are very important because they cut down costs, they reduce misunderstanding, and they make the process far more efficient for all parties concerned. Now, we also have this initiative from the Asian Business Law Institute, together with INSOL. They have published okay, sorry, not INSOL, I think it's, sorry, I think I may have mistaken that. Okay, I think it may be the International Insolvency Institute from the US. Okay, they have published a set of Asian principles of business restructuring, which is very useful, right? Because it brings together the restructuring principles from many countries within Asia. Now, so I will conclude by saying that Singapore offers a great venue for that restructuring. Okay, we have effective mechanisms, right? I've gone through the different insolvency procedures for you, right? I think in this regard, it is important to point out that no, I will not shy away from that. When you come up with new legislation, it will take time for people to get used to them, and there will be teething problems. Okay, but I think I am optimistic that as our judiciary have managed over the last 20 years to develop the scheme into a viable rescue procedure, okay, for companies not only to not only to restructure financial debts, but also trading debts, right, which is of course very difficult to do, trading debts. Okay, our judiciary has that successful track record, so I think they should be able to overcome the teething issues, okay, presented because of the new changes brought about by IDA. Okay, and so if you look at this robust framework and Singapore as a vibrant financial sector and the significant cross-border insolvency developments, I will conclude by saying that Singapore is a great center for that restructuring, okay, for not only local but also foreign companies. Okay, thank you for your attention.
Thank you so much, Meng Seng. That was a very fantastic snapshot of the different laws in place and their interactions, because obviously India also has had one-time frameworks that the Reserve Bank has come up with, prudential norms, also has schemes of arrangement that have not been used as effectively as they have been in Singapore, and we have the corporate insolvency legislation. Now, many interesting takeaways from your lecture and the aspects that you did not have time for. We will do 4 or 5 more lectures on and hopefully you will not say no. But the first key question that I want to ask you is the aspect of how the pre-packs are structured and how your restructuring frameworks are structured in terms of bidding and resolution of a company undergoing distress. So when you say that third-party sale is a process option for restructuring, right? In India, we've looked at related party and promoter restrictions, which have been very keenly built into third-party sale for restructuring. And you're looking at that, the same restriction applying to pre-packs as well. Now, it sort of take us through how Singapore reacts to these kind of third-party sales, and what are the restrictions or safeguards that, or is it a completely different non-issue for a regime like Singapore?
Okay, thanks, Ishana. Okay, now first of all, I think when we use the terminology of pre-pack, we have to be very careful. Okay, because I suggested earlier that I think it is unlikely that Singapore will develop a pre-pack JM. Okay, now so the pre-pack, like if you talk to an American lawyer, the pre-pack, they will think of a pre-pack Chapter 11. Now, actually a pre-pack Chapter 11 and the Chapter 11, there's not much difference, right? I mean, you still have to go to court. It's just that the creditor voting mechanism is not necessary. I mean, you don't have that creditor voting mechanism. So in Singapore, when we think of a pre-pack, it is a pre-pack scheme. Now, in the pre-pack scheme, there is no sale. I mean, what you do actually is that you try to restructure the company's liabilities. Now, so in that process, if you convert that to equity, in a sense, you may say that that's a sale, but it's a hypothetical sale. You don't really sell the business. Now, but if you are concerned, I mean, from your question, right? I mean, if the concern is about sale to related parties, yeah, this is something that, of course, may happen in Singapore, right? It is not so much in a pre-pack scheme, okay, but rather in a global receivership or in the JM, right? I talked about the JM earlier. Now, so I mentioned a few times that I mean, in the JM, there may be a sale of the business, okay, either in whole or in parts. Now, in the global receivership, of course, there'll be sale, right? I mean, because the whole idea of a receivership is that you want to sell the assets to use the proceeds to pay off the appointing creditor. Now, so how do we prevent the sale from being abused? The short answer is we do not have any specific rules to prohibit related parties from bidding and from being the counterparty and from being the purchaser. So we don't have any specific rules. We rely on, you may say, the general framework, okay, to deal with it. So for example, if a receiver and it is important to note that the receiver, okay, will be a qualified insolvency practitioner, okay, a professional. So when the receiver conducts a sale, and one of the parties interested in the purchase is related to the debenture holder, right? Immediately you can see that there may be a problem there, right? Because there's a conflict of interest, right? So in this case, the fair dealing rule will come in. Now, this is a rule, of course, that applies generally to a sale by a fiduciary, right? So a fair dealing rule will come in to ensure that the sale is at a fair value. Now, it is very unlikely, and I've never heard of a receiver selling the company's business to himself or herself, or I mean to someone related to the receiver. So I have never heard of that. Now, as for a JM, similarly, right, I mean, when a judicial manager exercises the power of sale, he or she has to be careful, right? First of all, he owes fiduciary duties to the company, right? The judicial manager. Now, but in a sale by judicial manager, there's also a protective mechanism. As I told you earlier, in a conventional judicial management, okay, that means no pre-pack involved here. There will be a meeting of the creditors to approve the proposals put up by the judicial manager. So if the judicial manager is proposing to sell the business to some parties, right, the creditors will get to hear of it and they will get to vote on it. Okay, so this ensures accountability, right? So unlike the pre-pack administration in the UK, which has, as I mentioned earlier, generated a lot of controversy. Now, because in the pre-pack administration in the UK, what happens is that the insiders, together with the support of the powerful creditors, okay, mainly the secured creditors and maybe some important trade creditors, okay, they cause the putative administrator to conduct some kind of informal marketing to find buyers, right? So if sometimes, because this is just a very secretive marketing, right? You wonder, whether the marketing is proper, and not only that, there may only be one interested party to buy, and this interested party may well be an insider, right? Be a new company set up by the shareholders. The creditors are all kept in the dark. I mean, the except for those powerful creditors who are involved. So that's why I mentioned earlier that the pre-pack administration in the UK has led to a lot of unhappiness, right? Because people are worried that although you have an insolvency practitioner in the person of the administrator in position in the office, right? You're always worried that the insolvency, the administrator will not be able to exercise enough professional judgment and have enough integrity, right, to prevent a sale at the undervalue, for example. Okay, but then the evidence from UK actually is not so much that, but rather in the pre-pack administration, okay, the sale may not be at under value, it may be at a proper value, but the effectiveness of the prepaid administration, okay, compared to the compared to the normal administration, whereby you have to go through the whole process of calling creditors meeting, and the whole process may take a few months, right? So if you compare the two, the prepaid administration takes only 1 day, right? So it is cheaper, more efficient, and because there is no news, right? No public announcement of the company being in difficulty, so it can continue to trade more or less like normal. So the prepaid administration in the UK, okay, I think there is evidence to support that it is effective, okay, for the company to run its business and to reduce the cost. Okay, but the trouble is that the savings in the cost and the efficiency generated, right? All this surplus, okay, they go to the insiders, okay, the insiders and the secured creditors, okay, instead of being shared by the unsecured creditors. So the unsecured creditors, they are not worse off, in the sense that had the company gone into the normal administration, they are not going to be better in the normal administration compared to the prepaid administration. Okay, but they don't get to enjoy the surplus. Okay, so that led to unhappiness in the UK, and the UK government has proposed reforms. Now in Singapore, we have no pre-pack. As I said previously, there is no pre-pack JM, and I don't think there'll be pre-pack JM in the future, right? Because for secured creditors, I mean, if they really want to exercise their powers of sale, they'll just simply put the company into global receivership, right? So in global receivership, the fair dealing rule will come in, right, to prevent banks from being on both sides of the transaction, both as a seller and a buyer, right? So that has not been a big problem. And I would also say, although this is not a complete solution, but the fact that only insolvency practitioners, okay, qualified professionals, can serve as receivers or judicial managers, okay, that has certainly helped, okay, to ensure certain standards, and also because of regulation from the authorities. And also, I would finally add, Singapore is very small, right? We are so small. We are smaller than a district, for example, in Delhi or in Bangalore, right? So I mean, people know what is going on. News spread. I mean, you can't cover up, right? So yeah. So I think as far as I'm concerned, there is no evidence of abuse in this regard of sale to related parties. Yeah. Thank you.
That's quite a different perspective from where we are as a jurisdiction in terms of enforcement and trust. So that's a very different perspective. And
Yeah.
I want to kind of take away very importantly the difference in the term pre-packs, because the combination of Chapter 11 and threshold differences for smaller companies or smaller businesses has been done in India. So it is it's a combination framework that is being introduced, which leads me to a wrap-up question, Meng Sang. Now, we've mentioned fair dealing, and we've also mentioned, fair and equitable as an aspect in Singapore, the Singaporean framework and law as well. India as well, in its corporate insolvency regime, has introduced a fair and equitable test, primarily to make sure that there is not one-sidedness in how the creditor is voting on a particular resolution plan. And of course, it is a creditor-driven process. I won't necessarily say it's a creditor in possession process that the corporate insolvency law is today. Can you give us a little bit of a snapshot on what is the fair and equitable test that the Singaporean law applies? What are the parameters, and does it at all play a role in the redistribution of assets?
Yeah. Okay. Thank you, Ishana. Oh, definitely. The absolute priority, I mean, the fair and equitable standard, right? That encapsulates the absolute priority rule in Chapter 11, right? And if you look at American literature, they, at least some, okay, if not all, American literature will tell you that the absolute priority rule is at the heart of Chapter 11, right? Because This rule evolved because of American experience with equity receivership, right, with the large bankruptcies of the railway companies. Now, so from experience, they realized that the fear when companies engage in debt restructuring is that the powerful senior creditors, okay, they may work together with the shareholders, and together they exclude the junior creditors. Okay, now, so if that happens, you can see that there will be an inversion of the ranking, right? Because the unsecured creditors rank ahead of the shareholders, right? Rank ahead of the shareholders. But why is it that that thing happened on the ground? The reason is very simple, right? Because the equity receivership, just like Chapter 11, just like scheme of arrangement, these are all debtor in possession regimes. So although the company is insolvent, right? At least in some sense, the shareholders, and through the shareholders, the directors, they are in charge. I mean, they run the business, so they are the ones proposing the rescue. Now, so they have the whip hand. They can create trouble, right? I mean, if you don't give them something. So therefore, the secured creditors, the senior ones, they will see that it is to their advantage to work together with the shareholders and the directors, and together they carve up, right, the carcass of the company, and they just share between themselves and exclude the junior creditors. So to prevent that, the American courts, right, over many years, they fashioned the thing called the absolute priority rule, right, which, put simply, the idea is this. Now, first you look at the statutory ranking of the claims against the company, right? So creditors first, followed by shareholders. Now, the idea is simple. If you have a senior class, okay, that has not been paid in full, okay, because company is insolvent, so if a senior class has not been paid in full, then no class that is junior to that class is entitled to have any claims against the company or any interest in the company, okay, unless the class that has not been paid in full, the one that is standing in front, they agree to let the junior class keep something or have something against the company, right? I mean, of course, even though if you have not been paid in full and someone is still behind you, but you're happy for the someone behind you to also have something, then of course it's fine, right? I mean, because you agree to it. But if you disagree to anyone that is junior to you having something against the company or having something in the company, then since I have not been paid in full, you shouldn't get anything, right? So that's the idea of the absolute priority rule. Now, so some of you may wonder, I mean, the way I put it, right, wouldn't that suggest that because in many Chapter 11 cases, you will see that the unsecured creditors, right, they are not paid in full, but yet the shareholders, they still get to retain something in the company. Okay, usually not a lot. Initially, they will have 100% of the shareholding, right? But after the Chapter 11, the 100% may be weighted down to maybe something like, let's say, a few percent, but it is still something in the company, right? So we may wonder, why is that the case? Now, the answer is because absolute priority, the working of absolute priority rule depends on valuation, right? You need to value the company's assets, right? The company's business. Because when I say that, right, if a class has not been paid in full, no class junior to it can get something or retain something unless the senior class agrees. No, that depends on the judgment of whether the senior class is paid in full or not. You need a valuation, right? You need to value the company's business in order to see where the value breaks. Because the shareholders will say, no, the company is not insolvent, right? I'm still in the money. So therefore, you can't say that I'm out, right? So and you can see that valuation is very messy, right? I mean, it's not a science, it's not exact science, right? I mean, it depends on judgment, and when you engage experts, they will come up with different tests, different methods. So valuation fight is usually very costly, very expensive, and the future is uncertain. Now, so pragmatic creditors in America, okay, they instead of suffering the cost and the time involved in fighting over valuation, okay, as a pragmatic solution, okay, they will negotiate with the shareholders, right? Or senior creditors negotiate with the junior creditors and say, come, let's do something together, right? So, and if the dispute is between the unsecured creditors and the shareholders, the unsecured creditors may be happy for the shareholders to just have something, right? Because you may have many unsecured creditors, so the cost to them, right, for letting the shareholders keep something in the company will be spread out within a big group of creditors. So for them, they may think that why not, instead of a bitter fight and incurring a lot of costs, right, legal costs and court hearing and all that, and the uncertainty. So they may take that pragmatic approach. Now, same with senior and junior creditors. So they may say, heck it, why should we fight over this, right? Might as well settle on let's negotiate and settle. Okay, between the senior and the junior creditors. Okay, but having said all that, right? I should emphasize that there's something about Chapter 11 that sometimes we may not be so aware of, which is that over the last 10 to 20 years, there has been two worst of Chapter 11 in America, right? You have the very large companies like GM, Chrysler, and all that, okay, very large Chapter 11s, and on the other hand, you also have very small cases. Now, so for the very large Chapter 11s, nowadays, actually, many of them, they do not go through the restructuring plan anymore. They just do a sale. They call that the Section 363 sale. Now, so in a sale, you don't have all this restructuring plan talking about absolute priority rule anymore. So that's why although the first thing when we read about Chapter 11, it is that we will be told that this is a debtor in possession regime, but some people say that this is only half the story. Right nowadays, there are definitely some Chapter 11 cases where it is no longer debtor in possession, but secured creditor in possession, because I think the market reality is that secured creditors, they still hold the whipping hand. It's all a question of function of bargaining power, right? Because if you need rescue financing, okay, you usually only get them from the existing creditors. They know the company best, right? So if you need help from the existing creditors, they have a lot of power. They have a lot of say over your restructuring process, right? So therefore, if the secured creditors, if they demand, the company may do a sale instead. So in that sense, if you see some of the recent large Chapter 11 cases, the shareholders are completely shut out. Okay, so the proceeds of the sale are just simply shared between the senior and the junior creditors. Now, of course, I mentioned GM, but GM is a different thing, right? In the GM case, the president was involved, right? I'm referring to President Obama. He was involved. When the president is involved and you need money from the treasury, the outcome is of course different, right? GM is no standard Chapter 11. Okay, so I will stop there.
Thank you for that, Meng Tseng. Obviously, very great alternate perspectives there, and a lot to think about. Particularly now that we switch over to UK right after this lecture and talk about the UK restructuring scheme with Sarah Patterson. So that's going to be a very different perspective as well. But I want to thank you very much for spending this hour and plus. As expected, we ran overshot with us today. And I hope to have you back again and again every semester.
Yeah. Thank you, Ishana. I apologize, for taking more time than originally planned. I'm sorry to the audience. Thank you. I'm sorry, for being late. I've taken up more of your time. Thank you very much.
Not at all, Meng Tseng, and have a good day. I'll see everybody at 3:30 then. Bye-bye.
Yeah. Okay, bye-bye. You too. Bye-bye.